Hey, my name is Zach, and I am a student at the University of Oklahoma College of Law, and I'm a citizen of the Cherokee Nation. I'm also a graduate of the University of Virginia, where I majored in politics, and I was the very first to minor in Native American Indigenous Studies at the University of Virginia. Today, I want to talk to you about an issue that just came out of the Supreme Court. It's a case called Haaland versus Brackeen. And so this case was about a 1978 law called the Indian Child Welfare Act, also known as ICWA, ICWA. And it's been an ongoing battle for a few years now, and it's been a contentious issue for even longer than that. So what the ICWA says is basically that if you're going to remove a child who is Native American, you have to put them in a family home or with a tribal member or with a member of another tribe before you can consider placing that child with somebody who is not Native American. So this is being challenged on a couple issues. The one that's most concerning to tribes is that it is challenging it on the basis of being a race-based classification. And there's a couple reasons why this shouldn't be overturned on this basis, and that is simply because it is, under the law, it is completely based on tribal citizenship, also called tribal membership. There's a couple different ways that different tribes will refer to it. My preference is tribal citizenship. And there was a case called Morton versus Mancari, and that was a Supreme Court case that dealt with a hiring preference for Native Americans in the Bureau of Indian Affairs. And so this case basically ruled that Native Americans, if there's a classification based on tribal membership or tribal citizenship, that it is not a race-based classification, but rather a political one. This is important because it determines what level of scrutiny the courts will use in determining whether a law is permissible under the Constitution. If it is a political classification, under the Equal Protection Clause of the Constitution, it cannot you can discriminate or provide preferences or apply law unequally if it is a political classification, as long as there is a rational basis. So that just means as long as the government has a good reason to be doing what they're doing, they can do it. There's a step above that called intermediate scrutiny, where there has to be an important government interest and has to be closely tailored to affect those goals. And then there's the highest form of scrutiny called strict scrutiny, where there has to be a compelling government interest, which means it has to be really, really important that the government does it, and it has to be enacted through the least restrictive means. And it's called strict scrutiny because it's really hard to meet that standard. And that's used to apply when it is something like a race-based classification. So it's not that race-based classifications will always be illegal. It's just you have to have a really, really good reason to do it, and you have to do it with as little restriction as possible. So if Morton versus Mancari is upheld and is applied to the Indian Child Welfare Act, then the tribal citizenship classification under ICWA will be examined under rational basis, which means it's very easy to get through. If it is examined under strict scrutiny, under a race-based classification, it would be very difficult, not impossible, but very difficult for the law to stand. And historically, Clarence Thomas has been especially oppositional to the law, as has been Samuel Alito. These are both conservative justices, but I want to be clear that this isn't a political issue. One of the strongest supporters of Native American rights under the law on the Supreme Court at this moment is actually Neil Gorsuch, Donald Trump's first nominee to the Supreme Court. And regardless of where you stand on the political spectrum, if you're conservative, that doesn't necessarily mean you're an opponent of the Indian Child Welfare Act, and it doesn't mean you, if you're liberal, that you're going to be a supporter of the Indian Child Welfare Act. I know of liberals who hate ICWA. I know of conservatives who love ICWA. And so this isn't a political it shouldn't be a political issue. It has become so in recent years, but I want to emphasize that the political leanings of the justices shouldn't influence you where you think one is going to come out on Native American issues. So that's very important to know. And the other way that the Indian Child Welfare Act was being challenged is based on it violating the commandeering clause of the Constitution and various other portions of the 10th Amendment or other doctrines from the 10th Amendment, basically saying the government went too far in enacting the Indian Child Welfare Act. They didn't have the authority because this is purely state law that should rule. Historically, family law matters have been in the domain of state courts, and the 10th Amendment says that any powers not reserved to the federal government are reserved to the states. So taking that principle, if you're applying it very strictly, which the Brackeens did, they wanted to say that family law is a state matter and the federal government cannot intervene in family law matters. And I'm glad to say that the court rejected this issue. The United States Supreme Court decided in a large majority that the Indian Child Welfare Act does not violate principles of states' rights and does not violate the commandeering doctrine. The commandeering doctrine, it also comes from the 10th Amendment, but it's specifically stating that the federal government, especially Congress, cannot impose or commandeer state entities to perform federal policy. But the Supreme Court rejected this argument because they say, and it's right, they have a lot of good reason to back it up. I highly recommend you look at the reasoning. Amy Coney Barrett, one of Donald Trump's nominees, she wrote the opinion, and she says that the commandeering doctrine applies to commandeering state executives, and it applies to commandeering state legislatures, but it does not apply to commandeering state courts. And the reason for this is because of the supremacy clause of the Constitution, which says the Constitution, treaties, and laws made in pursuance of the Constitution are the supreme law of the land. So what that means is whatever federal law is, that has the power to preempt state law as long as the federal law isn't violating some part of the Constitution, and as long as the federal government has authority to be doing what they're doing. If there's a dispute between federal law and state law, federal law applies. And the Supremacy Clause specifically says that state judges are bound by federal law. So because of that, it does not violate the commandeering doctrine. Furthermore, just because family law matters have traditionally been in the domain of state courts, that doesn't mean that federal law cannot affect family law matters. And that's really important because, as I mentioned, the Brackeens were challenging this, saying that family law is a purely state matter, and so the federal government doesn't have the right to intervene. But the court said no, just because it's primarily state courts doesn't mean the federal government can't. So that was really important. Another issue was that they were saying, because of these weird nuances of federal Indian law, one of the arguments was that there weren't any treaties that supported this, and the court didn't. The court said that there weren't any treaties, but that wasn't necessary because in invoking a treaty isn't necessary to enact the legislation. There's a clause in Article 1 of the Constitution called the Commerce Clause, and it states that the federal government has the authority, specifically Congress has the authority, to legislate in affairs pertaining to interstate commerce, foreign commerce, and commerce between Indian tribes. So this has been called the Indian Commerce Clause. And the court makes a distinction between the Commerce Clause generally and the Indian Commerce Clause specifically. And I can't remember if it was in the opinion or in one of the concurrences, but it was also stated somewhere that the Indian Commerce Clause, the Interstate Commerce Clause, and the Foreign Commerce Clause, while stated together, are three distinct legal entities and are interpreted differently, which is really important. So while interstate commerce generally is restricted to economic matters, not purely, and that's a bit of an ongoing debate, but while that's traditionally limited to trading and economics, the Indian Commerce Clause is not interpreted that way. So this was brought up because the Brackeens stated that the Commerce Clause doesn't authorize this federal legislation because children are not commodities. And if children are not commodities, then this isn't commerce, and the government doesn't have the authority to act. But the court rejected that argument, saying, you're right, children are not commodities. However, the Indian Commerce Clause has been interpreted to be a grant of plenary but not unlimited authority, plenary, not unlimited, and it's been interpreted as the exclusive right to govern within Indian affairs. And Gorsuch, in his concurrence, takes a little bit of issue with some of the framing. He says that Congress's power is not actually plenary, but is very broad. And the reason he says that, I get the sense, is, and I'll talk about this in another video probably, but when I've had time to read through the concurrence a little bit more, but his argument feels like it's more that Congress is more limited in governing Indian affairs than it is with respect to between tribes and states, because Gorsuch does say that the authority to govern between tribes is exclusive to the federal government, and states have virtually no authority to deal with tribes. So this is a very important distinction, that the Indian Commerce Clause grants Congress very broad, if not plenary, authority to govern within Indian affairs, not just trading with Indian tribes or even trading with Indian individuals. That authority is granted in the federal government, and it is not restricted purely to economic activity. So that was another important point made in the opinion. And unfortunately, the opinion did not deal with the racial issue brought up, whether this is a race-based classification. The concurrence from Neil Gorsuch kind of hinted at it. It did reference Mankari, but it did not explicitly say Mankari is and should remain good law. So, however, this is still a win because Morton versus Mankari was the law of the land before Brackeen, and Brackeen, the court in Brackeen said that they simply did not have standing to bring the claim. So the parents didn't have standing because there was no way to redress the alleged harm, because the Brackeens had already adopted the child, and at least one of the children, but there was not a way to redress the alleged harm. So there was no standing. And they said that states states were involved in this case as well, especially the state of Texas, states do not have authority to challenge. There's a legal doctrine where states can bring suits protecting their citizens, basically as if the state was a parent. But states do not have that authority when suing the government, the federal government. So that was where the court came down and said, we're not dealing with this issue because there is no standing. So on the states' rights arguments, total win across the board. The court said on every argument, you fail. You cannot challenge the Indian Child Welfare Act on commandeering grounds or any other states' rights grounds. The 10th Amendment does not remove the federal government's authority to govern in the Indian child welfare realm. So that's a win there. However, they explicitly did not deal with whether the Indian Child Welfare Act constituted a race-based classification. And that's really important, and it was highlighted in Justice Kavanaugh's concurrence. And I was actually surprised that Kavanaugh concurred. I was expecting him especially to dissent alongside Justices Thomas and Alito, who both wrote dissents. So Thomas and Alito have both been very vocal about not supporting Indian law as it stands. And so they both attacked, they have both historically attacked the Indian Child Welfare Act as a race-based classification. And that's also the most important, which is why it's a little disappointing to me that they didn't deal with the issue. And Kavanaugh very clearly stated he believes that it is a race-based classification. It's just that these parties didn't have standing, and he looks forward to ruling on the matter in the future when there's a party with standing. And so that is pretty disappointing because I was hoping for a clear victory on this. It's kind of punted down the road for now. Morton versus Mancari stands. And the reason that's really important is because basically all of federal Indian law in the United States is based on this idea that tribes are political entities with inherent sovereignty that predates the United States. And treaties are evidence of that. But tribal sovereignty does not come from treaties. Tribal sovereignty precedes treaties, and treaties are evidence of that sovereignty. And that was an issue that Justice Gorsuch dealt extensively with in his concurrence. And so I was really excited about that. And Justices Sotomayor and Jackson, I believe, were on that concurrence as well, at least in part. So that's a really important issue. And if later on the court is to decide that the Indian Child Welfare Act constitutes a race-based classification that would subject it to that strict scrutiny that I talked about earlier, and it would be very difficult to win on that. However, I believe there is a way that even if it is a race-based classification, which it is not, there's a way to win. The reason I don't think that the Indian classification is a race-based classification is that it's based on tribal citizenship. And tribes set their own terms for memberships. So if you're Navajo, you have to be 1/4. And so, or Dene is the actual name of the tribe, but known as the Navajo Nation. To be a citizen in the Navajo Nation, you have to be 1/4. I am a citizen of the Cherokee Nation. The Cherokee Nation does not have any blood quantum requirements. So blood quantum is the idea that you divide up your how much Native you are. And there's a lot of debate about it, and I'm not a fan of it, and neither is my tribe. And so all you have to do to become a citizen of the Cherokee Nation is to prove you have an ancestor on the Dawes roll, because they figure if you have an ancestor who is a citizen, and that passes down through the generations, that's often called jus sanguinis, or jus sanguinis, or I'm not very good at Latin, but it's basically the law of blood. So your citizenship passes down through your ancestry, your genealogy, your blood. And it's sometimes criticized because it has a racist connotation in the United States. However, the United States has blood law, where if your parent is a citizen, you are a citizen regardless of where you've been born. And the other option is jus soli, which is the law of soil. So if you're born in the soil, in the territorial jurisdiction of a political entity, then you are a citizen. The Cherokee Nation has this blood law. It does not have jus soli, and the United States has both jus soli and jus sanguinis. But other countries have one, the other, both. So it's very complicated. Tribes are not unique in this. So it's based on this citizenship that's been passed down from generation to generation. It's called lineal descent, and some tribes use lineal descent, and some use blood quantum, which blood quantum is still lineal descent because you have to have a certain quantum of ancestry descending from a particular role or particular roles, and like I said, it depends on the tribe. But because it is this classification, each tribe is different. It is not a race-based classification, but a political one. You can be 1/8,000th Cherokee and be a citizen of the Cherokee Nation. If you were to take a DNA test, you probably wouldn't see any Native American ancestry with that low of blood quantum. You could look and be genetically 100% white, and you would be 100% Cherokee because it's a matter of law that you're associated with the Cherokee Nation. So that's one reason it's not a race-based classification, and that's really the main point. But also, historically, you could be a citizen of a tribe without having any ancestry whatsoever, and this has been largely done away with. There is a issue with my tribe called Freedmen, and they are descendants of people who were enslaved Africans, enslaved by Cherokee Nation citizens, and after the Civil War, the Treaty of 1866 said that Cherokee freedmen were as native Cherokee, which made them entitled to citizenship and all the rights and benefits of citizenship. And federal law currently generally does not recognize freedmen as Indians. However, legally, I believe they should be. And there was a federal case that stated that Cherokee freedmen and their descendants are entitled to citizenship within the Cherokee Nation. And that was binding on the Cherokee Nation, and the Cherokee Nation Supreme Court actually removed any references to by blood because of this federal case. And it was still being challenged by Cherokee Nation citizens, and I did not believe it should have been challenged. I believe the proper interpretation of the treaty and that federal ruling is that anywhere the law says Indian, it includes freedmen. Freedmen are legally exactly the same as Cherokees, quote unquote, by blood. And so that's the other reason, is because if you are able or have historically been able to have people of other races coming into this political entity, then it is not a race-based classification. And Thomas and Alito disagree with that argument. It's not really dealt with in the majority opinion. Like I said, it was dismissed. It was rejected for standing issues. So this is going to be an issue in the future. However, if the court decides that it is a race-based classification, I believe that the Indian Child Welfare Act should still stand. Last year, 2022, I wrote an article in the Virginia Review of Politics, you can look it up, about, and I called it SCOTUS Considers Genocide. And it was about this case, Brackeen versus Haaland. And in it, I argued that the Indian Child Welfare Act is necessary to be in compliance with the United Nations Convention on the Prevention and Punishment of Genocide, which has been ratified as a treaty in U.S. law. So this is supreme law of the land, the United Nations Convention on Genocide, or the Genocide Convention, I'll just call it that because it's too long. So the Genocide Convention has not only been incorporated by ratification in the Senate as a treaty, it has also been basically copied and pasted as statutory law by Congress and has been for a very long time. So, one of the things that can constitute genocide under this convention and under statutory law on genocide is the removal of children uh, with the intention of destroying their cultural identity, um, which perfectly fits into uh, the Indian child welfare issue. And for a more in-depth history of that, highly recommend reading Neil Gorsuch's Dissent, or not Dissent, sorry, Concurrence, because he goes very in-depth in that history, where Indian children were taken and put in boarding schools, forced to be assimilated, and how Indian children were bought and sold, how parents would, white parents would want to take Native children and Christianize them and force them to be good Christian white people, basically, despite their brown skin. And so that's the historical context. And this didn't go away. If you look at some of the language from the parents in the case, they talk about wanting to adopt more Indian children. And why is it that they're targeting Native children specifically? Why is it the Goldwater Institute is going after Native children specifically? And it's largely religious organizations trying to missionize Native children and assimilate them. It's just a continuation of that. Also important to the discussion is that up until the 1970s, Native American women were forcefully sterilized. And just to give you kind of a basic understanding of how big the problem was, it was somewhere around 1 in 4 Native women were forcefully sterilized without their consent. They were sterilized. A lot of them didn't even know it was happening. And it was somewhere around 1 in 4 or 1 in 3 Native children were removed from their families. So when you take the cultural connections and the personal identification aspects into account, from the 1970s, the government was basically cutting the Native population in half, or the future population in half. And so that's why the Indian Child Welfare Act was passed. It was a backlash against these gross practices that constituted genocide. And it's because of that that the Indian Child Welfare Act is necessary. And that's the argument I made in the article. So, yeah, this is not over. I really hoped it would be, but the court kind of punted. And I think it was the case that probably the 4 Democrat-appointed justices plus Gorsuch, or the 3 Democrat-appointed justices plus Gorsuch, so 4, wanted to deal with that issue and, or at least kind of reference it, even if it wasn't in the opinion. Probably something like they don't have standing, but if they did, we'd rule this way, which the court has done before. And I think it was Amy Coney Barrett and Brett Kavanaugh and possibly Chief Justice Roberts who probably wanted to say, no, we're not going to consider this issue. Kavanaugh wanted to deal with it the other way. But I think Amy Coney Barrett and Chief Justice Roberts wanted to just deal with it on standing grounds and not even deal with the issue. I don't know that, but that's kind of what I suspect. They wanted a strong opinion on the 10th Amendment issues. So this fight is not over. We're going to have this fight about whether Native Americans are to be considered a race-based classification and subject to strict scrutiny, which will decimate federal Indian law, or if the Mancari precedent will stand and Native Americans will continue to be considered political entities and having these political affiliations. So that's the Brackeen case, and I hope to make a video dealing more with the concurrence and then also with the dissents. But that's for another day. So I guess that's where I'll leave it. So just to summarize, the Indian Child Welfare Act has been upheld in the case of Brackeen versus Haaland, or Haaland versus Brackeen. I get those switched around. But it has been upheld. States cannot bring any more challenges based on 10th Amendment unless they come up with some new argument. but the case is decided on commandeering grounds, on states' rights issues, on overreach of federal authority. It's been settled on those grounds. It has remained consistent with precedent so far on race-based classification, but there are going to be more challenges, and I hope this video reaches somebody and kind of educates you a little bit about where the history stands and why the law is what it is now. And I hope you'll support tribes in their efforts to preserve the Indian Child Welfare Act, because it is important. It's when you have your native children being removed and forcefully assimilated, it decimates the long-term viability of tribes as political entities, as cultural groups, as a people, which is the definition of genocide. It meets the statutory definition of genocide. So it is really important that we protect the Indian Child Welfare Act. So thank you for listening. I know it's been a long video, and I hope this has been helpful.